Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, huge news today. Now, for those of you who have been geeking out on this channel for a while, you know that we did a video a couple of months back about how you could help the Firearms Policy Coalition sue the state of Washington to stop the magazine ban. And then just last week, we did a video, because we were exactly 30 days out from the implementation of Senate Bill 5078, your standard capacity magazine ban, warning you that time was running out to get magazines. Well, there has been a huge development. Now, I don't want us to get too optimistic, but it is something that we definitely need to talk about. So today we're going to do a huge update, because here comes the lawsuit to overturn Washington's magazine ban. Okay, so hot off the presses, the case we're going to be talking about is Sullivan v. Ferguson. Now, there are a lot of plaintiffs and defendants named in there, but the two main parties is Gabriella Sullivan, a regular, lawful, and responsible gun owner like yourself, against your Attorney General, Mr. Robert Ferguson. Now, the plaintiffs to this action are actually Miss Sullivan, Rainier Arms, the Second Amendment Foundation and Alan Gottlieb over there, and the Firearms Policy Coalition. The named defendants, of course, are the Attorney General Bob Ferguson, as well as the Chief of the Washington State Patrol, and then several sheriffs and prosecuting attorneys for several counties in the state, including King County, Thurston County, and Kitsap County. Now, the purpose of this litigation is to do one thing and one thing primarily, and that is to stop the implementation of Senate Bill 5078 from taking place on July 1st. This is what's called injunctive relief. The moving parties, the plaintiffs here, Ms. Sullivan et al., are moving to enjoin the state from allowing, and thus allowing law enforcement and the prosecuting attorneys in those various jurisdictions from enforcing the new magazine ban effective July 1st this year. In fact, the complaint here specifically requests, plaintiffs respectfully request that this honorable court enter judgment in their favor and against defendant as follows. A, declare that Washington's ban on manufacturing, importing, selling, or offering for sale magazines with a capacity over 10 rounds violates the right to keep and bear arms as guaranteed by the 2nd and 14th Amendments to the United States Constitution. And the action also requests that the court enjoin the defendants, their officers, agents, servants, employees, and all persons in active concert or in participation with them from enforcing the provisions of this act and all related laws, regulations, policies, practices, and customs that would impede or criminalize the exercise of the right to keep and bear arms. Now, in support of this motion, the plaintiffs here make several very good arguments. I want to highlight only a couple of them, though, because otherwise this video would take too long. But I will put the link for the entire pleading down below. And this is obviously a case that we're going to very carefully watch. And this will probably be the first in what will turn out to be a series of videos as we track this through the appellate courts. The plaintiffs begin by claiming their lawsuit is as simple as this. The state of Washington has criminalized one of the most common and important means by which its citizens can exercise their fundamental right of self-defense. By banning manufacturing, importation, distribution, and the sale of standard capacity firearm magazines that can carry more than 10 rounds of ammunition, the state has barred law-abiding residents from legally acquiring common ammunition magazines and deprived them of an effective means of self-defense. And the plaintiffs further state, absent relief from this court, defendants will violate the constitutionally protected rights of Washington's law-abiding citizens and reinforce the erroneous notion that the right to keep and bear arms is nothing more than, quote, a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees, citing to, of course, McDonald v. City of Chicago. And the complaint does, very fortunately, point out one of the most obvious points about this type of legislation, which is, worse yet, defendants will commit these constitutional violations without any realistic prospect of diminishing the misuse of firearms or the incidence of horrific mass shootings. The state's ban on standard capacity magazines will do nothing to address or ameliorate these public policy concerns. All it will do is leave law-abiding citizens more vulnerable to attack from better armed and more ruthless assailants. And then, again, to state the obvious, but to make sure you get a couple of little jabs in a time when local governments, municipal and county governments are looking to defund the police department, we are also encountered with a state government which is looking to disarm its otherwise lawful and responsible gun owners. The plaintiffs see it this way. During uncertain times, with the recognition that governments have no legal duty to protect the people they serve, there is no guarantee that law enforcement will respond to an individual's 911 call during the crisis or after it, let alone in a time to prevent a crime, and those who choose to exercise their fundamental and individual Second and 14th Amendment protected rights cannot be denied those rights. Uncertain times are precisely when fundamental rights, like the right to keep and bear arms for self-defense, must be protected. Now, the reason there is multiple plaintiffs is that each one brings their own set of unique facts to this case, which allows the plaintiffs to attack the law on various levels. For example, Miss Sullivan is a regular citizen like all of us out here who are just lawful and responsible gun owners. She happens to own a SIG P365 with a standard capacity magazine which exceeds more than 10 rounds. She is planning on continuing to not only use it, but to purchase further magazines in the purchase. Now, Rainier Arms, a very reputable FFL here in the Puget Sound region, is engaged in the business of selling firearms and firearm components, and they have for many, many years sold magazines which exceed 10 rounds and plan on doing so post July 1st because that is the normal way that business is conducted in that industry. Take both of those and attack the statute, and now we have an opportunity to determine the constitutionality of this statute from multiple levels. This is very good lawyering on the part of the plaintiffs' counsels here, and they have employed a law firm out of Washington, D.C., which upon my research shows that they have handled many very significant Second Amendment litigations in the past, and I think that this argument is in good hands. The problem here, of course, is that we are arguing this in front of the Western District for the state of Washington in the Federal Circuit Court, which means if this thing ends up in appeal, it's going to end up in the Ninth Circuit. Now, we know Duncan v. Bonta, the magazine ban challenge out of California, won at the trial level, one at the three-judge panel level of the Ninth Circuit, but once they impaneled the full panel, well, it was all over for Bonta, and that case now is before the United States Supreme Court for review to see if they will accept it for oral arguments. In addition to that, we know out of the Ninth Circuit recently that a three-judge panel struck down the age restriction for those purchasing semi-automatic rifles, the age restriction which is currently being kicked around by the United States Congress right now, but the Ninth Circuit three-judge panel actually found that banning 18, 19, and 20-year-olds from purchasing that weapon was violative of their Second Amendment rights. Now, I anticipate a full-judge panel to be impaneled on that and probably to see a different decision. The problem here is that we're arguing this issue under the Second Amendment. What's the problem there? Well, we've done a video down before, and I want you to go back and pay careful attention to that because I believe that the language under Article 1, Section 24 of the Washington State Constitution actually provides even greater protection than that which is given to us through the Second Amendment. And if we really want to get technical here, no constitutional amendment actually gives you the right to protect yourself. No constitutional amendment actually gives you the right to keep and bear arms. Those are inalienable rights that were given to you by your Creator. And what the Second Amendment says, and what Article 1, Section 24 of the Washington State Constitution says, is that government cannot take that right away from you. Okay, so once again, the case is Sullivan v. Ferguson, multiple plaintiffs, Miss Sullivan, Rainier Arms, Second Amendment Foundation, Firearms Policy Coalition, many defendants. I will put the link for the original filings down below. And yes, we will keep tracking this case very closely and keeping you updated. Now listen, if you have any more questions about this appeal or anything else related to your Second Amendment rights, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.